Don't die without a will. It's a hassle your family won't thank you for. Wills are one of those things people avoid doing. Even people who have created wills often fail to update them on a regular basis, making the will as good as useless or sometimes as a point of contention when none was meant. Family feuds, and not the game show variety, erupt even when no harm is meant, so creating a will isn't just a way of getting all your ducks in a row. It's a way of keeping the peace and letting your family members continue to treat each other, if not kindly, at least civilly. Perhaps unjustly, but rightly, the rich and the famous are great object lessons for this. James Brown, often referred to as the godfather of soul, died in 2006. He left a will, leaving the majority of his estate to charities for the purposes of helping disadvantaged youth. In 2020, more than a dozen years after his death, the New York Times declared James Brown's will. Is it inching toward closure after 14 years? Brown's grandchildren were to receive education scholarships, and his costumes and other effects were to go to 6 of his children, but the majority was to go to a charitable trust called I Feel Good. However, a dispute with a spouse who it appears was not legally his spouse due to a prior marriage with no divorce has sent the will back to court multiple times. South Carolina law plays a part in the contention because that state provides that a third of an estate be awarded to a spouse regardless of a will. Termination rights for the 900 songs attributed to Brown are where the real money is at, and those rights were not part of the will, but also put the family in contention since Brown's widow sold termination rights to 5 of his songs without informing the other beneficiaries. 14 years after Brown's death, no money had gone to Brown's charity, but the courts are celebrating because there is a light at the end of the tunnel. Howard Hughes left the stuff of legends and a giant court battle. A gas station attendant who supposedly gave Hughes a ride before his death was one of the intended beneficiaries of a handwritten will found on a desk. That infamous ride was famously made into a movie in 1980. It took 3 years to settle that court case, and the gas station attendant was not one of the lucky winners. People leave money to pet charities all the time, but in 2007, Leona Helmsley left $12 million to her pet Maltese. Helmsley, known as the Queen of Mean, owned, among other things, hotels, the Empire State Building, and other properties. It's tempting to say that the courts are going to the dogs, but in this case, the poor Maltese lost most of its riches to Helmsley's grandchildren and some charities. But the real winners here were the 4 executives of her estate that were awarded $100 million in fees. If the other cases seem amazing due to one error, how much worse could it be when multiple errors were made? That's the case of Anna Nicole Smith, who at the age of 26 married J. Howard Marshall in 1994 when he was 89. Marshall died just 14 months after marrying Smith, and in his will, he left everything to his son, E. Pierce Marshall. Smith disputed the will, saying that Marshall promised her half his estate. She was joined in the battle by Marshall's other son. A 20-year battle ensued. In an even uglier turn of events, Smith filed for bankruptcy, and E. Pierce Marshall sued her for defamation. Smith countersued and was awarded $475 million. The case gets uglier because the case has been heard twice by the Supreme Court, at which point neither E. Pierce Marshall nor Smith were still alive. Smith, who died of a drug overdose, left her estate to her son, but he was already dead as well. Smith had a daughter at the time of her death, but had not updated her will. 4 men claimed they were the daughter's father, and so a custody battle ensued. Sometimes disputes occur, because they are too simplistic for the situation, as in the case of Jim Morrison, who was young when he died and his estate was modest at the time, but grew to be worth millions due to his 25% interest in his band, The Doors. The other end of the spectrum also occurs, as in the case of Robin Williams. Williams thought he was really clear when he outlined his estate, and while he was clear about money and real estate, he failed to take into account the memorabilia, clothing, and other items that he had not specifically distributed. Even simpler still, the artist formerly known as Prince died without any will, leaving his music, his brand, and everything up in the air. You don't have to be a celebrity or a wealthy person to run afoul of disputed wills, family conflicts, or other legal issues that tie up your estate in riddles and knots. Here are some myths about wills. The state will get everything if I die without a will. Every state has laws for how to handle estates in which someone dies without a will. States do get the estate if no family members are found, so if you have children that you have not acknowledged, or you know where your long-lost cousin is, a will can make sure that the state doesn't get your estate. Otherwise, there are inheritance laws that determine who is first to inherit, but again, if you don't want the state to decide, you are better off with a will. Another myth: probate is a lengthy process. Mostly the time frame for probate is to allow creditors to come forward. The time frame is relatively short, between a couple months to a year mostly, once again depending on the estate. The cases listed above took longer than that time frame because family members got involved and disputed the wills. Third myth: probate costs an arm and a leg and won't leave my family with anything to stand on. Many estates don't require probate. Even those that do often pay far less than people expect. Get the facts before you decide that you can die without a will. Creating one may be less hassle than not having one, and your family might like each other afterwards, assuming they like each other now.